Mr. Dunlop.
My lord, my ladies, good morning.
Good morning.
I am going to seek to supplement my skeleton argument, not supplant it, so I would ask that you revisit it in due course. And I don't want to weary you by repetition this morning. I'm going to address each ground in turn. And so turn, if I may, to the first, which is the allegation of the case that the Upper Tribunal erred in law in its approach to First Tier Tribunal's decision. To start, I hope you'll permit me to go to one authority, that of Flannery and Halifax, which is the authority to which the Upper Tribunal referred in awards drinks. And as you'll appreciate, in the Upper Tribunal, that was the decision to which the Upper Tribunal in this case made reference in its decision on lack of reasons. Flannery will be familiar to you. It is found in the first bundle of authorities at tab 6.
Sorry, I just need to get it up.
This was an appeal from a county court judgment on an action for professional negligence in respect of a property valuation, and picking it up at internal 379 B, which you find on page 201. The central issue in the action was one of fact, namely whether the property was or was not suffering from foundation subsidence at the time of the valuation officer's inspection.
Sorry, I've lost you.
I'm so sorry. 201.
Yes, I'm on.
At D.
Oh, D, sorry.
D. My apologies. See the central issue?
Yes, I see.
And then over the page, taking it at A, the judge accurately set out the crucial issue. And just pausing, I say there's some analogue here because at 108 Judge John Brooks set out HMRC's contention and what he had to decide. And then with that all set up, he concluded, and you see, and if I can just read you, ask you to read the part of his judgment down to C.
Yes.
So in short, he preferred the expert evidence, but didn't explain why. And we see now, picking it up at E, that passage is the only passage in the judgment which purports to set out the reasons for the decision. The appellants complain that in truth no reasons are given. We do not know why the judge preferred the defendant's expert evidence to that of the plaintiff.
Where's that at G?
At E. So sorry.
Yep, thank you.
And then right at the bottom of this page, the judgment is entirely opaque. It gives the judge's conclusions, but not his reasons for reaching that conclusion. And so over the page, Lord Justice Henry notes that A, the case thus raises in stark form the question when the failure of a judge at first instance to give reasons for a conclusion essential to his decision may of itself constitute a good ground of appeal. And then there are some very familiar observations. The first line of the next paragraph, there's a general duty to give reasons. The first line of the following paragraph is not a useful task to attempt to give absolute rules. And then the passage that is sidelined from G, we make the following general comments on the duty to give reasons. And if I can invite you to read comments 1 to 4 over the page.
Yes.
And so in particular, I draw attention to the line on 204 at B, where the dispute involves something in the nature of an intellectual exchange with reasons and analysis advanced on either side. The judge must enter into the issues canvassed before him and explain why he prefers one case over the other. And with respect to the learned Judge John Brooks, this is what, in essence, HMRC say he failed to do in his judgment in this case. And then finally, on this page, the respondent made various submissions about it, and I just identify the court's response to point, the first point in the last paragraph of the page. There seem to be 4 things wrong with the respondent's analysis, and then this is the only point I wish to draw to your attention. First, we do not know whether the assumed thought process was the judge's actual thought process. So when you're looking at a judgment and you're being asked to infer what the judge must have been doing, as in effect my learned friend was inviting you to do when it comes to the question of, well, if there was significant dual use, where do we see his analysis as to what that meant for the integrity of the floor space method? It's not there. The next stage of my points is just to so that's
put Flannery away.
Yes, you can. Thank you. That's the legal authorities and principles done. The next point is, before we go to the FTT's judgment, it is just to make clear what HMRC's case on the dual use of the areas was. That's obviously necessary in order to be able to judge whether or not the First Tier Tribunal dealt with it. HMRC's case on dual use had 2 elements. The first was that there was, to a significant degree, economic use of the bar areas and also the restaurant and entertainment spaces for the gaming business. The second was that because of that significant degree of dual use, and in particular with the bar areas, the floor space method was fundamentally flawed as it worked on the premise of exclusivity of use. On the first, the points that HMRC were making as regards dual use in the economic reality are probably easiest to find in the Upper Tribunal's decision, which is tab 7 of the core bundle, as you'll be familiar, and page 122 at paragraph 162. And perhaps I could just invite you to read 162.
Yeah.
So, I mean, none of those points are particularly surprising, respectfully. The Hippodrome was no different to any other casino in providing food and drink and place to have a smoke or a cigar. It was necessary to have non-gaming areas for regulatory reasons, to enable people to take a break from gaming. The very quality of the provision was a point of competitive advantage. So insofar as the Heliot Steakhouse is a particularly nice restaurant, that only buttressed the economic advantage to be gained by the casino as a gaming business. It increased the dwell time of those coming in. And the material that was obviously gone through in depth in the First Tier Tribunal of the casino itself made these things perfectly plain. And just to give you a taste of it, if you could turn back in this Upper Tribunal judgment to page 116. And it's internal paragraph 67 of the First Tier Tribunal's judgment that is here being cited. Casino games are great. The experience gets even better when you have a full-fledged restaurant to satiate your taste buds. However, if you smoke, there aren't many facilities like the Hippodrome Casino that have a dedicated smoking terrace for your smoking breaks. The casino houses a 2-level smoking terrace that's equipped with dedicated bar and offers a wide range of cigars. You can smoke and drink while sharing your life experiences, and so on. When you're at the Hippodrome Casino, you don't have to ever worry about getting bored, thanks to the wide assortment of games we have to offer. However, when you feel like taking a break, visit the smoking terrace for a quick breather, and so on. Turning back to 162H on page 123, there was, just as a factual point, the lack of profitability of the hospitality and entertainment businesses in the period.
Sorry, what are we looking at?
H. And I was careful before the First Tier Tribunal to make clear that I wasn't making a submission that because the hospitality and entertainment businesses weren't profitable, that all the costs in effect were being used for gaming. I was not making that submission, and that, as I'll come to in due course, is an important point of distinction to how the submissions were advanced in London clubs. Rather, it was a more modest submission, which was that point of fact was evidentially relevant when it came to the tribunal drawing inferences about how costs were being used. And a summation of my submission on that point can be seen at paragraph 163, which if I can invite you to read that too now, please.
Yeah.
So that, in brief summary, is the first leg of the two-point submission on dual use. The second, as I said earlier, is that what did that dual use mean for the floor space method? HMRC's case was simple. Given that method works on the premise that the areas identified as bars and so on are entirely for the supplies of food, drink and taxable admission tickets. That is therefore contrary to the economic reality of the situation. In effect, the logic of the floor space method was that the gaming business and the gaming areas could be lifted up and put somewhere else entirely, such that there's no bars or smoking terraces or what have you, and it wouldn't make any difference. And that's plainly contrary to the reality. And if there was economic use of the bars and so on for gaming, then the floor space method made no allowance for that at all, so it can't be accurate. To illustrate this and add a bit of colour to my submissions, can I ask you to turn to the supplemental bundle at tab 9 and page 215. I hope what you'll find is a colourful floor plan of the basement of the premises. And I can see from my lady
it doesn't really work on screen, does it?
In
Would
the
it be better
PDF,
in hard
it requires
copy?
rotation. So
You'll know how to. I don't know how to rotate it. So why don't I just look at it in hard copy? Would that be an easier thing to do?
yes, I think if you right-click, my lady, on the PDF, you'll have something should come up allowing you
Mr.
to
Donald,
turn.
despite your best
Yes,
efforts,
no, no.
it's not working with the old dog.
so
You can't do the new
I will.
trick,
I will. It's actually probably easier
got it
to
here.
see in hard copy anyway.
I'm always reassured to find that hard copy works better.
So this was an allocation plan undertaken for 2013 to 14, and this was basically how the relevant areas of floor space were drawn up. And I think you will recall, and we can turn to it in due course, but the First Tier Tribunal usefully put as a first appendix to its judgment the allocations. In fact, these plans, these detailed plans, are only produced for one of the years, which is why we're looking at this. So this is the basement floor, and as you'll see from the key at the side, we have the gaming in purple, and this area of some 300 meters squared, that's the main big purple area, was at the time known as Lola's Casino.
Lola's Casino.
And then immediately above on the page, I hope you're seeing it, it is difficult to see, but 40.71 square meters. Mm-hmm. That was a small bar which predominantly served the gaming area. Now, behind that small bar, you see a further green area of 55 square meters, which in fact I think the cellars, and likewise the other two green areas were were stores, so not customer-facing space. So in terms of what the customer would come down here to find, you'd find that 300 meters square of gaming space and a bar servicing it. And yet, of course, the floor space method treats that bar as exclusively for the purpose of taxable supplies, and likewise the areas enabling the bar, the stores and cellar, in the same way. And HMRC says, well, that's plainly wrong. Over the page, you'll find the ground floor. And if you've not had the fortune to go into the Hippodrome, it's an impressive space, the ground floor, because that main gaming area in the ground floor has a very high vaulted ceiling all the way up. Now, we have in the central green area a bar, and that bar on the evidence was servicing the gamers. That was the purpose of the bar. And for your note, that's the Upper Tribunal at 154C. So again, one can say, well, it's not really right, is it, to say that that green space is exclusively for taxable supplies? Over the page.
Just pausing there. Yes, that's 3.39 square meters of green.
Yes, that other 33.39, I think that's a that's a sort of supply area, if I recall correctly.
Yep.
And in the same way, I should make clear that I think the other purple areas on this ground floor, the 91 square meters was, I think, the slots area, and then the larger pentagonal area on the left was, I think, live tables, so electronic tables. But there's also some support areas. So I think the rectangle may have been the cash desk, something like that. What you'll also note, obviously, about this ground floor is the great expanse of orange, which is the general area. And in fact, we'll come to the net allocations in due course, but one of the aspects of this floor space method was that only 43% of the ground floor space was actually specifically identified as being for bars, restaurants, or gaming or entertainment. And so most of it was non-allocated areas, of which this general area was a great example. And I think the logic would be here that, well, people coming in would be having to walk through these areas to get to any aspect of the hippodrome, and that's why it's general. But it is a significant aspect, as I'll come on. So then over the page we have the first floor, and so here we have the theatre at the 199 square metres there. There's, I don't know if you can see the semicircular green area where it says 288 square metres. That's the penny bar, which the evidence that was used by everyone. And then along the bottom right, you may just be able to make it out. It says lounge. That was the lounge area. And then...
What is a lounge area in this context?
It was somewhere where people could take their drinks and sit down and have a break.
I haven't got that. That's, where is it?
Sorry. So do you see the orange area that says 158 square metres on the bottom left?
I've got a 153.
Maybe it's my... Sorry, that's it's probably my eyesight. I do apologise. Exactly. So there, and then so further right to that,
okay. So,
you walk through from the penny bar into this area, which was the lounge, which became renamed the Boozy Tea Room.
Okay.
And then above that, so in a sense opposite the theatre, you had the first bits of the Heliot steakhouse, and I think these are small tables. And then it's a bit complicated because there are voids and so on and so forth. But then on the right-hand side, you have the kitchens, both for the restaurant, but also there was a 24-hour menu for food supplied elsewhere.
That's all part of green, is it?
That's all part of green. Over the page, we have the second floor, which had the gallery of the theatre, and then further levels of the restaurant, and then in green, and then at the far right, two private dining rooms. And then the other bits of pink are dressing rooms for the stars of the theatre. Over the page, we have the third floor. This is where you find in green the smoking terrace and bar, and then the poker rooms in purple along the bottom.
So the green area in the middle of that is the smoking terrace?
Exactly. There's actually two smoking terraces, and that's the first. That's right, my lady.
It doesn't seem very much like a terrace, it's in the middle, but never mind.
No, it's hard to make out from this diagram, isn't it? The building is actually comprised of a number of buildings. So you have along...
Different levels.
Okay. In a sense, there was a void. So at the bottom, if you look at the bottom bit where the gaming rooms are, I think I'm right in thinking that's Cranbourne Mansions or Terrace.
Yes.
And then there was the original Hippodrome, which is the building with the big void in the middle. And then, in a sense, there was then this triangular bit between the two, which has then been infilled with the outside. It's very hard to see, I appreciate from
Thank you. I'm sorry, that's not directly relevant.
No. And then, likewise, then over the page, we have the fourth floor. And to my lady's question, again, you'll see then in the same manner, in that open space, you have the further terrace. And also then what's known as God's Casino, which is a casino that overlooks the impressive vaulted space, as well as various plant rooms and staff rooms. So if we then turn to the core bundle tab 11, page 179.
What is 179?
179 is Appendix 1 of the
I see.
ICT's judgment.
Yep.
And if we could just look at 2013 to 14, which is the year that maps directly.
Have we just looked at diagrams that were 2013, 14
Exactly.
as well? Okay.
So this is the allocations that match directly that diagram. And as you can see at the bottom, you have a total of the areas. And so I'll just make further 2 points. The first, as I've already trailed, is that only a minority of the building was driving the allocation of the whole. So the included areas of gaming, bars, restaurants and entertainment add up to 43% of the whole. And the only point really to make about that is that obviously is liable to exaggerate any inaccuracies in that primary allocation, because they're effectively doubled, because the excluded areas are treated as being used in precisely the same proportion as the included areas.
And the reason you include those areas is because those are the areas that the appellant says are the areas that are being used in a direct way to make outputs of one sort or another.
So the whole is determined by the use on the appellant's case of the directly related areas.
Just help me, I see a column for Chinese community centres.
Yes.
Is that taken into account in the calculations?
It's a good question, my lord. And I pause because I presumed that it was excluded from.
So your 43% would be based on the aggregate of
that is
2622 and 974.
That may be right, sir. And perhaps I can get back to you. It's a very fair point, my lord.
I suppose, in fact, if you had to add in this, that element to your calculations, the 43% would become a smaller number.
Yes, but if you've
already taken into account, then
it would get larger.
Yes.
Yes.
Yep.
And then the second, a further point on the general areas is that of those general areas, as you can see, that plainly the largest is the or the unallocated areas is the general area. So that's the walkways and toilets and so on and so forth. Now, there's obviously a temporal dimension that we haven't, we briefly touched on yesterday, the dwell time when people come in, but there's also the temporal dimension of things. And so, and it's a point the Upper Tribunal made at 155C, but the casino and certain bars were open 24 hours. Conversely, the theatre in the periods in question didn't, in fact, have a show every day even. And the restaurant was open 5 p.m. to midnight. So that's just another sort of point in the mix and as a point of background. But I think the biggest point to make on this allocation is just when you're looking at the included areas and the size thereof, you will see that the bar area, 910 square meters, is bigger than the restaurant, or, well, that's obviously including the kitchen, but the restaurants and entertainment spaces combined. So, while before the First Tier Tribunal there was quite a lot of discussion about the theatre and their attempts to use it as a strategic gaming asset to drive gamers, and then feeling that that wasn't particularly successful, and finally, at the very end of the period, we're considering the adoption of a somewhat different approach with the Magic Mike show. The integrity of the floor space method can't be determined by findings of dual use or otherwise as to regard to the theatre. That would be to miss the much bigger point, which is that the bars and restaurants provide a much bigger area and dominate the taxable aspect of the equation.
And what's the point there that you say the bars and the restaurant are examples of where dual use is perhaps at its highest end?
Yeah, the bars would be the example where it's the highest. Probably, if you pushed me, the next would be the kitchens, which we use for 24-hour food, and then the restaurants, and then the theatre. And that's not making a concession about dual use in respect to the theatre, but I think it is a realistic reflection of what HMRC's case would be on the extent of dual use of those respective areas, because one wouldn't necessarily expect to find a cabaret in a casino, but one would expect to find a bar in a casino. I mean, one of the difficulties in making submissions to you now, my ladies, my lord, is that there's so much detail that was before the First Tier Tribunal that would be very laborious to go through with you now. And quite a lot of it actually is in the Upper Tribunal's judgment in respect of detailed points about the theatre business, the restaurant business, and so on. But the wider point, really, at this juncture, is merely to say, insofar as it occurred to you, well, I really don't see how, in respect to the theatre, there was compelling dual use in that regard. It doesn't ultimately change the analysis. In my skeleton, and I use this just as a convenient place to make the point, at page 27 of the core bundle, I think it's behind tab 2, you have a table which sets out the respective turnover levels, the standard method recovery percentage, and conversely the recovery percentage on the appellant's method. So that was HMRC's case on dual use in its twin dimension. And as I've already said, HMRC's case was not advanced on the basis of London clubs, where HMRC had argued that it was all about the gaming. And I think this point might be most economically made by reference to the Upper Tribunal judgment at page 104 of the core bundle. At paragraphs 92 to 95.
Meaning you'd like us to read this?
Yes, I'm so sorry, my lord, yes.
So it was almost like a single supply argument, was it, an LCM?
Almost, although obviously in the different context. I think that the argument was really that it was a reductive argument to say everything is about gaming.
All about gaming.
It's all about gaming, and therefore, really, it's you're lucky to recover the amount that you get under the standards method because everything is ultimately.
It's all exempt, really.
Yes, that's what's justifying everything. So it was quite a reductive argument. It wasn't sort of arguing single multiple supplies.
No, okay.
But yes, exactly.
But it looks like a sort of echo of that.
And that's one of the points we made before the Upper Tribunal. That in fact, the First Tier Tribunal was maybe getting
in a muddle.
And one can see why, in fairness to the First Tier Tribunal, because of the language that was being adopted in London Club, and stepping back a further level, one can say, well, it's possible. Obviously, didn't represent HMRC in London Clubs, but Aspinall's was a case where only 10% of the food and beverage was bought, 9% was given away, and there was the argument that this is all about gaming, and then the same argument was used in London and clubs and so on. But that was not the argument here. Now, my learned friend took you, I think, when discussing, and this is a small point, but when discussing the First Tier Tribunal's decision and paragraph 110 of that, which we find, yes, 110, it's page 176. And you'll forgive me for responding on this, possibly a point of detail, but one of my learned friend's submissions yesterday is that, in effect, I was also making contentions about principal activity and so on, and perhaps that gave rise to the reason for the response to the tribunal in due course at paragraph 125. In the supplemental bundle at page 195, we have the transcript of the First Tier Tribunal, and picking it up at page 28 there, at line 8, and I was going through various factual points in the submission. Paragraph 4, second point, the gaming business is the principal or core part of the appellant's business. Now, that submission is not to denigrate the restaurant, bar, theatre businesses. It's not to say that they are merely ancillary to gaming or have no ability otherwise to themselves attract custom. It's just a reflection of the economic reality and so on. So respectfully, there was no ambiguity in HMRC's case before the First Tier Tribunal. Those were the two elements of the case, namely that there was a dual use, and if there was, that rendered the floor space plan unreliable. And so it is that we can now turn to the First Tier Tribunal, because HMRC's case is that core case found no proper reasoned response in the First Tier Tribunal's decision. So we can pick it up at 176. We were just there, and at 108, it's right that my core submission was identified at least the first limb of that. And then we have the problem thereafter that nowhere is that case properly dealt with. Nowhere is there a clear finding about the extent of dual use. Nowhere is there any discussion about whether, if there was significant dual use, how the floor method could be coherent or reliable. Now, my learned friend invites you to read the paragraphs that follow from 113 to the end as acknowledging dual use, but finding and reasoning that such dual use was not such as to invalidate the floor space method. And as I've already said, nowhere can either point be clearly found in the judgment. Further, there is an inescapable tension in my learned friend's submission. He's constrained to say that both, well, there was significant dual use, and to be meaningful, that's significant dual use. But also that when it comes to the integrity of the floor space method, that was not significant. And my lord, you'll recall yesterday as my learned friend was making the point about, well, the business would look like a different animal. And you interjected, but none of that is inconsistent with significant dual use. And the response was, well, with respect, it is inconsistent with significant dual use. That must be the tribunal's conclusion. That was, I think, an hour and 44 minutes in yesterday, which the wonders of YouTube, is what I can say. But that's the tension there. And what one has at 120 to 125 is the tribunal responding to a different argument, which HMRC had not advanced, namely that HCL's business was all about gaming. And just 3 sub-points on that.
So what, the LCM argument?
In effect, yes.
They're sort of projecting onto you an argument. You said
exactly,
they're projecting onto you an argument you weren't really running.
Exactly.
Which was that it's not all about gaming. You
Yeah.
accept it's not all about gaming.
Yeah.
But, I mean, is it fair? I was trying to get a grip on your case. It's more to do with, you just say it's all a bit more complicated than that. You can't, I mean,
Yes, exactly. It's not to say that, take the bars, we're not saying that no one would go to the bars independently.
Yeah.
But some people plainly go to the bars as a break from gaming. And the economic use of that bar area serves both. And that economic use can also be seen in the context of an extremely profitable gaming business and a hospitality business that is losing money. And it's not to say, it's not to say, the building would look exactly the same, because, in order to invite people in from the street to go to the bar, you might have particular signage, come to the bar. You don't need to gamble, you can just come in, whatever it is. But that doesn't obviate dual use. In London clubs, and obviously the decision would repay detailed reading to fully understand the ways in which the arguments were deployed there. But in effect, the argument became one about the profitability of the other aspects of London club business. And it became, the proxy for the argument became whether the taxable businesses in London clubs were businesses in their own right. And HMRC were saying, no, they're not. So everything's about gaming. So you can't have this floor space method because everything's really about gaming and these aren't profitable and so on and so forth. Whereas in this case, HMRC didn't adopt such a reductive position. It reflected a slightly more nuanced view. So as saying in response to the all about gaming, as we've just discussed, first, that is a different argument to dual use. The second is that one has to be very careful about the St Helens counterfactual being adopted in 121. As you recall, St Helens wasn't a case about a floor space method at all. St Helens was a case about effectively a school sports complex and whether the use of that should be apportioned on a time basis as between hours of school use and hours of sports club use. And as a way of testing the economic use of the business, Mr. Justice Warren thought, well, what would it have been like if you didn't have the sports club? And the answer is, well, it wouldn't have been any different. And he used that in that paragraph 76 as a way of reasoning that the economic use for the school of this sports club went beyond simply the hours when it was being used by the school. It was part of the offer to prospective parents, to existing parents, and so on. So it is not a sort of one-size-fits-all approach or counterfactual to be adopted in any partial exemption argument. And as I said to the Upper Tribunal, as the Upper Tribunal accepted, if there was a counterfactual in this case, the better one would be, well, you say that the gaming areas are exclusively used for gaming, and that's the basis of floor space methods, as my correct. And the bars are exclusively for taxable suppliers. So, well, imagine if you just had the gaming areas on themselves. How would that work as a casino without the other? And then the third point on this, and I appreciate this is perhaps a point of detail, but it is possibly worth still bearing in mind, is it's worth bearing in mind what the underlying costs are that are residual and being argued about on the annual basis in this case. Now, those were set out in the First Tier Tribunal's decision at Appendix 2, and you can find that on page 181, tab 11. So you see the 5 largest items in take 2014. You can see our rent, building maintenance, which included, there was a spreadsheet setting out what that included. It included costs of utilities and so on. Cleaning, marketing, and security. And I mean, it's a small point possibly, but in Aspinall's, a lot of the discussion was about the major refurbishment costs that had been undertaken in order to provide these opulent surroundings and everything else. And I accept that there's a capital goods aspect to the appeal before you, but on the annual basis, in terms of the costs that are being allocated by this method, we have rent, utilities, security, cleaning. Those of themselves aren't necessarily going to how, say, the restaurant looks or the bar looks. They're not actually really driving the appearance at all. So there's a slight disjuncture there, insofar as the First Tier Tribunal say, well, it's, you know, these costs wouldn't have been incurred if it was all about gaming. But talking really about the appearance. I mean, these aren't, I mean, cleaning, obviously, it's helpful to have a clean business, but the costs weren't in the same way. Well, we've incurred this enormous cost for very, very grand, you know, fit out of X or Y. The ongoing costs were more prosaic. Now, as to, so we're in the First Tier Tribunal decision, and as I say, I mean, in a sense, it's the problem of trying to prove a negative. I mean, you can't see the reasoning, so I can't identify where it is the reasoning on the points. At 125, we have really what becomes a summary position for the reasons given above, and having a regard to all the circumstances. We've come to the conclusion, so this is the concluding part, that the supplies of entertainment and hospitality cannot be regarded merely as an adjunct to or an amenity for gaming. My learned friend says, well, you know, there's no appeal by the Upper Tribunal didn't ultimately decide ground 2, so you know this aspect is irrelevant. But the question about ground 2, which is that they applied the wrong test, is in a sense the flip side to ground 1, which is that they didn't answer the question we asked them. So respectfully, it's a distinction without a difference here. The only points that my learned friend points to is respect of, well, where is the dual use submission answered? Are paragraphs that are plainly not answering it.
I mean, in that sense, it is slightly distinct, isn't it? You can say, oh, okay, we're not satisfied. the First Tier Tribunal applied the wrong test, but nevertheless say they didn't address themselves to the right question.
Yes, my lord. Perhaps I expressed myself poorly. The point as to whether or not they applied the wrong test at 1 to 5 is no answer to whether they gave a reasoned response to our core case. HMRC appealed, and in the supplementary bundle at tab 10, page 242, this is part of the skeleton to the Upper Tribunal. And you'll just see from that first sentence of paragraph 38 the point that I've already made to you this morning, which is that HMRC's dual use issue had two limbs, and the absence of reasoning of the First Tier Tribunal extended to both. And I only make this point because insofar as my learned friend goes through the First Tier Tribunal, there obviously are points at which one can say, well, they're saying not merely, there's an implication of a degree of dual use there. I have to accept that. There is no finding about the extent, but there certainly isn't any reasoning about, well, if you are finding some dual use, then where does that leave a method predicated on exclusivity of use? So then to the Upper Tribunal, my learned friends' complaints about it. The first is that the Upper Tribunal erred in drawing a false distinction between the approach to an alleged failure to give reasons and the approach to an alleged failure to give adequate reasons. On this, the Upper Tribunal judgment shouldn't be read like a statute either. And read as a whole, there's nothing problematic about what the Upper Tribunal was saying at paragraph 61. I want to pick up, which is the paragraph being criticised in this respect. So I want to pick up first at paragraph 42 of the decision, which I momentarily bear with me. So 42 starts the passage where the tribunal is recording my learned friends' submissions on approach. And these points are very familiar to you. But I would, going over the page at 96, paragraph 45, there's then this lengthy citation from Volpe. And I would ask you just to highlight 2.6. Reasons for judgment will always be capable of having been better expressed. An appeal court should not be subject to narrow textual analysis. And then moving through to the tribunal's own discussion, we pick it back up at page 99, paragraph 60. And here, the Upper Tribunal is accepting the points from the authorities that my learned friend referred to. And you see from the final sentence of 60, appellate tribunals should not rush to find errors of law simply because they might have reached a different conclusion on the facts or express themselves differently. There's potentially some ambiguity in the language of adequacy of reasons, because one angle of that could be how well expressed the reasons are. And another aspect of adequacy of reasons might be, better expressed as sufficiency of reasons. Are the reasons there? Is there enough there to work on? And I'm going to turn to 61 last, if I may, because at 62, the Upper Tribunal, and this was the point of sort of distinction to the authorities previously discussed, went to awards drinks. And paragraph 85, it is well established that a failure to give reasons or sufficient reasons for a conclusion which is essential to a decision may constitute a freestanding ground of appeal. So in that sentence is, again, not in any way problematic, but it's clear that it's encompassing within a lack of reasons, a lack of sufficient reasons. And it's plain from paragraph 62 that the Upper Tribunal was taking that approach in mind. And so when you then go back to 61, which is the criticised paragraph, and the line, well, first we have this ground of appeal is not a complaint about the adequacy of reasons given. And I think reading it not as a statute and fairly in the whole, it's saying, well, it's not about how well expressed the reasoning is. What HMRC is saying is the FTT failed to address the central issue, that there was a lack of reasons on that central issue. And then they go into 62 and the unimpeachable reference there to the authority, which then in turn refers to Flannery, which we've seen. And the Upper Tribunal proceeds on that basis. So respectfully, the Upper Tribunal was plainly addressing the First Tier Tribunal's judgment from the correct basis. Was it clear from the First Tier Tribunal's judgment that the FTT dealt with HMRC's central case in its two-limbed aspect we've discussed? And there's nothing in the analysis that, lengthy analysis that follows from 65 to 81 to suggest that the Upper Tribunal did do anything other than direct itself to that proper principle. My learned friend's second complaint is really the substantive complaint about the conclusion the Upper Tribunal reached about First Tier Tribunal's decision. I mean, it's worth recalling that at some level that is itself an evaluative exercise that the Upper Tribunal is undertaking. And if you're with me on the first point, there's no error of principle in how the Upper Tribunal is addressing that question. One has to be slightly careful about interfering directly with the Upper Tribunal's decision simply if one thought, well, I would read it in a slightly different way.
You may be right. I slightly wonder. I mean, very often in tax appeals, what the Court of Appeal says is, well, forget about what the Upper Tribunal says. We'll just look at what the FTT said. You say this is different. There's
I don't think I
evaluation that has to be assessed.
Yes, I mean, I'm not saying I put it as high as, you're not able to consider whether the Upper Tribunal made an error of law and how it analysed, or the evaluative conclusion it made of the First Tier Tribunals. It's a more modest submission, I think, which is to say some caution's got to be exercised when thinking about the exercise the Upper Tribunal have undertaken, because it's not as though my learned friends identified an error of law in the approach. They've looked at it and tried to find reasons and concluded that there aren't.
I mean, that said, in a sense, you could leave out the Upper Tribunal. From your point of view, you say the FTT was wrong.
Well, but the FTT was wrong in a different way, because the FTT was wrong because it didn't give it reasons. Now,
yes,
the Upper Tribunal has given reasons why it thinks the FTT was wrong.
Yes.
So it is distinct, respectfully, I think.
I mean, your approach is sort of double-barreled. The FTT was wrong, but even if it wasn't wrong, the Upper Tribunal wasn't wrong. No, I think the First Tier Tribunal was wrong, but insofar as you are being invited to reopen that, absent there actually being an error of principle in how the Upper Tribunal's addressing that question, there should be maybe some judicial hesitancy before simply saying, well, I actually think that I could see it elsewhere, because it's not as though the Upper Tribunal has acted such as no Upper Tribunal could do in considering that there were no reasons here. No, I mean, you may well be right, but in a sense, even supposing that one could say, well, the Upper Tribunal had approached things on the wrong basis, you would still say, well, the First Tier Tribunal didn't deal with things properly, wouldn't you?
My lord, you're right in that sense. If you felt, well, the Upper Tribunal has got it wrong, then the first point would be, well, remaking the Upper Tribunal's decision, we'd ask you to come to the same conclusion. But so, my lord, yes.
But I think what you're saying is that in thinking about whether there was a lack of or an absence of reasons in the FTT, the UT itself had to reach a judgment on that question, faced with rival submissions, and that there is an area of judgment. It might be quite a narrow area because it's quite a binary sort of decision, but there is still an area of judgment,
yes,
the Upper Tribunal, in approaching that question, that we should be careful about interfering with. Is that right?
Yes, in effect. I mean, I don't want to put this point too high. I mean,
No.
We consider there's no error in the Upper Tribunal's analysis,
Quite.
both in respect of the principles adopted and the substantive conclusions. But it is just of maybe even academic interest in passing that effectively it's a complaint about a judgment rather than the principles by which that judgment was reached. So on the substantive response, as I say, there's obviously the risk of repetition here, but the Upper Tribunal's decision was unimpeachable. And I direct you in particular to the concluding points at page 103. And paragraphs 78 to 80. Just invite you to read those again. So those paragraphs are encompassing the two limbs of dual use argument and the saying, well, there wasn't a proper response to it. and just over the page at 88 in a similar vein. It did not address the degree or extent of any dual use, whether it was material or significant. So on ground one, unless I can assist further, those are my submissions. Turning to ground two, this is of course the argument that the focus should be on whether the standard method is flawed, not on the proposed method to displace it. Now, there's actually quite a short way to the answer here, but I also, I fear, address
Go a long way around.
the long way around. But the short response is the following. First, EU law had primacy at all points relevant to the appeal. Second, as a matter of EU law, the only basis on which a method other than the standard method can be used is if it guarantees a more precise determination of the deductible proportion of the input of the residual input VAT, which in shorthand I call the Baumark test, but
So it guarantees a more
precise determination. And my lady, you'll recall that that proposition isn't in dispute. My learned friend took you to VWFS case yesterday, tab 19 of the bundle at paragraph 51, but says that. And third, there is no way of determining the use of a residual cost for taxable supplies other than by way of some method. Costs such as those at issue in this appeal are residual precisely because they are not used exclusively for the purpose of taxable supplies, and they're not used exclusively for the purpose of exempt supplies. So there will always be some method, even implicitly, being adopted in order to try to quantify the proportion of use. When I say quantify, I mean in the sense even to establish the proportion of use. So
Taxable
one could
use.
have,
It's a portion of taxable use.
yes, exactly. That would be great for my lady. So any number of reasons, ways, by time, by space, by number of transactions, combination, and so on. Now, my learned friend accepts this insofar as it goes to calculation. Yes, you have to have a method to calculate it. But it also goes to what my learned friend tries to separate as a prior stage, namely that of establishing a problem with the standard method. I mean, this is sort of evident from the basis on which the problem, the supposed problem with the standard method is asserted in this case. Because it said, well, we know that a third of the customers don't come for gaming, so the standard method must be wrong. That is an assertion, in a sense, well, implicitly, of a method. It's the footfall method. And so there is no way of getting to a problem with the standard method in isolation of an alternative to it. So those 3 points in combination come to this. When it comes to the apportionment of residual costs, there is a binary situation. Either the standard method is used, or an alternative method which satisfies the Baumark threshold is used.
Which is better. Is there anything in my thought from yesterday that if you're talking about the standard method, which has a blessing in the directive and so on, it's peculiar to start talking about defects in that. I mean, you can always talk about it being improved on, but it's sort of VAT heresy to say that there's something wrong.
My lady, exactly. And I'll come to this when discussing my learned friend's point about GMAC.
Okay.
But I can deal with it.
Whenever
but in a sense, I can make the point quickly now. Because the GMAC point is that, well, the tax tribunal is trying to find the right answer. And so, that gives the tax tribunal the imperative to search for a method if there are problems with the standard method. But my answer to that argument is, in effect, what my lady you just indicated, which is it would be wrong to say that if the taxpayer or HMRC failed on their special method and it reverted to the default to the standard method, that was in any way the wrong amount of tax. That is the right amount of tax until such point as it's displaced. So exactly as my lady says, there is no problem in that regard ever with the tribunal finding that the standard method applies. That's the default.
That's the default, okay.
So I've set up my stall in a sense on the sort of primary EU level. My learned friend's chief submission was on 107B and the language thereof. And my response to that is that, contrary to his argument, there is no real problem with one. We see it on page 162 of the authorities bundle, tab 4. So 162, sorry if I misspoke. And to an extent, there was already obviously discussion of these provisions yesterday. So, but the idea that 107B indicates anything else is a fallacious one, because as the learned court made the point yesterday, the trigger condition in this provision is that the attribution differs substantially from one which represents the extent and so on. So it is a comparative exercise. Now, if the use of the SMO by the taxpayer is accepted by HMRC, then there's no issue. But if HMRC says, actually, we don't accept the method that you're proposing by way of override, then it's a dispute between the standard method and the special method that's being suggested, the non-standard method. And so we go back to the criteria that must dictate how that discussion is determined. So there's nothing in 107B that requires the court first, or tribunal first, to be addressing the fairness or otherwise of the standard method in isolation. And even if it was, it would have to be read compatibly with EU law anyway. So to my own friend's secondary arguments on this. The first was, he said, well, it must operate in the same way as the PESM override situation.
The special method override.
Exactly, thank you.
notice, that's got a note. That's a special method. So it's unfortunately the acronyms are very similar.
Yes, it is.
The SMON is the special method with a notice. The standard method override has no notice attached to it.
Exactly. So the situation with the PESM override, there's the notice provision, and then there's the so we're in 102. B.
Well, the notice is A.
The notice is A, exactly.
Page 138.
And then when the notice is served, you get to 102B. And I mean, the short point on the analogy with PESM override is that the context is different. In a standard method override dispute, as we've just discussed, the discussion will be between the suggested other method and the standard method. But in the PESM override scenario, the dispute will be about the PESM and whatever the alternative ultimately might be being suggested. And the PESM does not have the same hallowed status as the default in European or domestic law. So in a PESM override situation, it may well be that the parties are not arguing about the displacement of the standard method.
Well, you won't be arguing about that, will you? Unless somebody
no, they won't be unless I mean at some level it may be conceivably that the PESM is there's been a notice because the commissioners think that the standard method
is the better way,
the better one, and then there is. But if that's the case, then you go back to the dispute that I've already discussed, which is as between the standard method and a PESM, and the Baumark criteria applies. And so on Vision Express, which is found tab 10 of the First Authorities bundle, and this was a case where there had been a PESM agreed on a floor space basis, and the commissioners then served a notice disagreeing with that. And at page 283 283 in paragraphs 32 to 34. Mr. Justice McComb agreed that the FTT's judgment, in effect, that the premise of the floor space method didn't work in that case because there wasn't a fair attribution on the rigid characterization of floor areas that the PESM proposed in that case. So I appreciate that's a point on the substance, not directly to what I'm talking, but just it's obviously notable in the present context. And then from 52, the
so 34 is saying your PESM doesn't work.
Yes, because effectively they're not rigidly one thing or the other. And then 52 turns to the appeal against the assessment. And what I would ask you to note from then 54 on page 289 is that Mr. Justice McComb doesn't resolve the amount. He considered, at the bottom of 289, I have considered whether it is open or desirable for me to express views on the underlying calculations. I have concluded it is neither. It is clear to me that the tribunal made no findings on the subject against which any appeal would lie. It seems that their view was if the parties could not agree upon the method of calculation, the matter would have to be determined at the further hearing. So, in a sense, division is caught in this judgment in an interim stage. It's not the outcome at all. They're just saying, well, the person that was displaced was properly displaced, and there's now an argument between you about what should replace it, and there may need to be a further hearing if you can't agree on that.
But it was, I'm sorry just to follow it through because it is quite tricky, isn't it? Where you have a special method case and a notice is served, in this case, in Vision Express, that was accompanied by an assessment to say this is what you owe us, taxpayer, because you've been over recovering your residual input tax. But in our case, on a standard method override, well, here there was no assessment.
No, there was. It's a bit complex, but
there is
the initial years were, the SMO was returned, so the box 6 had the full fact figure, as it were, on the basis of their floor space method applying, and the commissioners assessed for the difference between that and the standard method.
So there is an assessment.
There is an assessment, but then in later periods, it was done by ECN, an error correction notice. So the return was done on the standard method, but then
with the taxpayer saying, by the way, we don't think that's the right method.
Yes, and then the claim was
alternative.
Exactly. So it has both elements.
So where does that get us? That means that there is a dispute on how much is owed. So to Mr. Hitchmo's point, he says, well, look, it's all still out there because we think there is a problem with the standard method. And what's your answer to that?
Well, and that's the point, that if you've not displaced it, then the standard method is the right answer.
Okay. Yep.
So it's not that the tribunal is being constrained to find the wrong amount of tax.
So why did Mr. Justice McComb, as he was, McComb, or however he liked it being pronounced, I can't remember.
I wondered whether to make the point that Lord Justice McComb would like to be known as
I
Lord
do
Justice
apologise.
McComb.
He was very particular about it.
And I apologised yesterday.
McComb, is it, like haircut?
It is McComb.
McComb. Why didn't he just stop at saying the notice is valid, full stop, I don't need to go any further? Or did he in effect say that?
Well, because the parties haven't got to the stage of actually articulating fully the contentions about the basis on which the assessment was made. And so that's where you see it, paragraph 54, as I've taken.
Yeah. No findings. The tribunal made no findings. Oh, I see. So you say here that that's the whole point of this, right? That's what they've all been trying to do, is make findings about which is the right method of the two.
Well, what they seem to have done is they basically say, well, the existing floor space method is wrong, and so the notice is valid. Now there's a remaining dispute before us on the amount of the assessment, and unless you can agree about the method for that assessment, there may have to be another hearing. So that's the final line on page 290 at 54.
I think I see.
And so if the parties went away in this case and they said, well, HMRC said, well, actually, we think that the method should be the standard method, and Vision Express said, well, we actually think of an alternative method, then, if they couldn't agree, they'd come to the tribunal, one saying the standard method, one saying a special method, and then that would have to be determined on the basis of the arguments of the parties along the way I state. If both parties were in fact saying, well, on the facts of this case, neither of us are arguing about the standard method, then the resolution would have to be between two special methods. But either way, it's not the tribunal saying, well, the burden now falls on us to resolve this.
But procedurally, I think what I've got from you is that you say procedurally Vision Express is a bit different from this case, because we sort of, I'll need to reread it, but we land in Vision Express sort of halfway through a full story.
Exactly.
Whereas you say the story is already told here, it's whether
Exactly.
it's rightly or wrongly told. Is that right?
Exactly. So here, the statements of case, the statement of appeal, the response, set out to delineate the parties' arguments. The arguments are then, those statements of case are the basis on which evidence is obtained and argued about at tribunal, and it's a binary question as between the two contentions of the parties in the normal way. And if the appellant fails to establish that the floor space method is more precise, then you return to the default standard method, which is what HMRC was contending for. So, I mean, another way of, I suppose, putting the point on this difference between the standard method override and where there's a special method in place is that, and I'm at risk of repeating myself, but if there's a dispute about whether the standard method override arises, it will be a dispute as between standard method and the override method. But in the pessimist situation, it rather depends on how the parties articulate the position if that special method is wrong. They might be asking.
I mean, typically, I don't know, typically in special method cases, or quite often, you find it's just one bit of it that's a bit wrong or very wrong. Or anyway,
yes.
Is it this that there are many more differentials. If you're in the territory of special methods,
Exactly.
You're in a slightly different, you'd say you're in a different universe of...
Yeah, you're in a different situation. And so the operation of the special method override legislation shouldn't and can't determine the proper approach to the determination of a dispute as between standard method and the alternative method.
And just to be clear, would there, in our sort of context, be any objection to an appellant saying, well, I think this method is better, or I think that method is better, or I think the other method is better? I mean, is there any objection in principle to an appellant putting forward a number of possible methods?
I think it would be difficult to object in principle, providing that all the requirements of fairness to have all those things met were catered for. This is a point I'll sort of come on to, but as I say, it's all agreed that VAT questions are highly fact sensitive. So evidence is important. Now, where does evidence come from? Well, evidence comes from looking at the pleaded cases and working out, well, what are they arguing? What do we need to bring by way of evidence? How can we challenge it? And so on. So what I think would be unfair would, in a sense, what HMRC are facing in this appeal, which is, in a skeleton to the Court of Appeal, there's a submission of what a new method might be. When we're plainly unable to properly grapple with the rights and wrongs of a footfall method on the hoof and without proper evidential exploration. So, my Lord, I think, unless those behind me surveys, that's the response. Not in principle, but it's got to be ensured that the points can be properly ventilated and tested. The second point that my learned friend made was the wider question about the tribunal needing to find the right answer. and I've obviously already discussed this in brief in response to my Lady Justice Whipple's question. So, general motors is found in the second appeal bundle, tab 16, page 455. And this case concerned the deemed taxable amount of the self-supply of a car by the manufacturer of the car to itself for business use. And the argument was identifying the value of that supply and picking up at 459 at internal 989C, and then you see the provisions of VAT are in issue at 2, and then there are 3 different options. One, if there was goods identical in every respect to those being self-supplied. The second, if goods similar to those which were being self-supplied. And the third, if you can't get to value from A or B, the cost of producing the goods concerned if they were produced at that time. So that was how the tax had to be determined.
And this is all to do with manufacturers supplying themselves with cars at no cost, in fact, so there has to be a deemed cost of some description. So that's what you're driving.
Exactly. And the short point, but important one, is that that legislation was not dictating a calculation in default of a better one for that final bit of the cost of producing the goods. It's just saying you have to work out what the cost of producing the goods is. So it's not like a standard method calculation in that sense. And it's in that different context that we then have the observations that you have already been taken to at page 470, which is picking up at midway through paragraph 69. The tribunal should remember that its primary task is to find the correct amount of tax. So in VWF, there's a dispute about how we're going to calculate the cost of producing these cars in question.
You don't mean VWF, you mean General Motors.
The car.
Mm-hmm.
Yes.
Yes, in General Motors. So it was just a distinct context. And that exhortation to find the correct amount of tax while it would doubtless equally apply to a dispute as the present, doesn't lead to the conclusion that the tribunal needs to undertake its own inquisitorial approach, because the tribunal can be reassured that absent a better method, the standard method is the right amount of tax. I turn now to deal with a final point on ground 2, which is the problem, in addition to those we've already discussed, but the further problem with my learned friend's argument is it raises the prospect of effectively endless litigation, or litigation without end. Now, my learned friend's contention is that there are 2 steps: the identification of the problem with the standard method, and then the solution. And you've already got my primary response to that, which is you don't get to finding a problem without a method. But even if my learned friend was right about that, that would plainly raise very difficult issues. As I've already said, these are fact-sensitive questions, and so there needs to be clarity about what the cases are, and that's the purpose of statements of case, and there needs to be evidence on those issues. And the discussion yesterday gives some sense of the wholly unsatisfactory position that might prevail were my learned friend right. So the case is prepared on the floor space method, evidence is gathered in it, goes to judgment, and then on the contested assumption that my learned friend raises that there's a problem with the standard method, the tribunal says, well, we're not convinced about the floor space method, but we do think there's a problem with the floor space method. So we have
standard method.
Sorry, I do apologise. Yes. We do think that there's a problem with the standard method. So, okay, well, what do we do now? There might be something in customer numbers, and but that hasn't yet been properly explored in evidence. But it's not even just a matter of remitting for further evidence, because the parties would need to know, well, what precisely is the methodology that's going to be being tested? So it'd have to be remitted for new statements of case, on the back of which the parties could understand what evidence they might need to seek by way of disclosure and then witness evidence and so on. And then, let's say that comes through to hearing number 2, and it doesn't work either. But there's still a problem with the standard method, the taxpayer says. Right, so we're going to go round the houses for a third time with another method, and so on. Now, it may be in some cases that the parties may say, well, let's just agree X or Y. But in principle, once you say the court has to identify as the first thing whether the standard method can proceed, in effect, if it's fair or not, then you do risk, given the Baumark test, which is that anything replacing it must be better, this sort of endless and iterative process. And
it loses its status as a default position.
Exactly. And at this juncture, I'd respectfully turn you back to Temple Finance, which is in the authorities bundle at
18.
Thank you so much. It's paragraph 60 on page 539. Only 2 methods were before the FTT, TFLs and HMRCs. The FTT was not required to make its own inquiry as to whether there might be another method that was preferable. As Lord Carnwath said in the Supreme Court's decision in VWFS, where the parties are substantial litigants represented by experienced counsel, the tribunal is entitled to assume that the parties will have identified with some care what they regard as relevant issues for decision. I mean, in the present case, the appellant has the highest quality representation, and it's right that the tribunal can expect that the parties have identified the issues, and it's a matter of the tribunal to decide between those. As a final footnote to this, I just want to sort of make it clear that the submissions I've just made are not of themselves submissions about the tribunal's jurisdiction. They're submissions about the point at issue on ground 2, which is whether the focus should be on the standard method. So I'm not saying that there are no circumstances where a tribunal could suggest that parties consider a method, providing the requirements of fairness are met. And one might think of scenarios where the taxpayer might be a litigant person or similar. And you know, at the highest, the tribunal could say, well, if you want to advance methodology, then we'll put in place directions and so on. So I'm not saying that the tribunal doesn't have jurisdiction to consider these things, but what I am saying is that that is a real and obvious concern with the logic of Malone and Friends argument in trying to displace the default without there being any alternative. So unless I can assist further on ground 2, we are making progress. You'll be happy to hear. And at least in part, that is because ground 3 only really arises if you find against HMRC on ground 2. So ground 3 is the ground that if the Upper Tribunal should have considered if the standard method was reliable, then it should have come to the conclusion that it wasn't. And in substance, this third ground seeks to attack the finding in paragraph 195. We have found that a third of customers do not gamble, and that is a proxy, a physical proxy for economic use, but it is not a good proxy for economic use. When gambling, customers are spending considerably more. Floor space or customer numbers do not more fairly reflect economic use. Now, that wasn't, in any case, a material part of the decision, but I do appreciate that it arises in the event that Ryan was right about, well, you know, if there is a problem with the standard method, then was the Upper Tribunal's observation on that a proper one? But that finding, namely that the number of customers not gambling on a survey is not of itself dispositive of economic use, is a finding that the Upper Tribunal was entirely fully entitled to reach. Now, I've given my skeleton argument two examples of this. And the first is a hypothetical example. So, a retailer leases at great cost a prestigious central London building from which it sells luxury cars at great expense and toy replica cars at a loss. And a customer survey finds that a third of visitors come to the shop just to buy the toy cars. It would plainly not follow that a third of the economic use of the building was for the sale of toy cars. It doesn't follow. And that example is not a million miles away from the facts of this case either, because taking and as I set out in my skeleton, sorry, I should have said where. It is paragraph 38 now, page 40 of the core bundle. So taxable income in 1718 was £9 million. So a third of the customers not gambling would be, assuming that all the customers spent the same amount, and you can quibble with that assumption, but on that assumption, that they would bring 3 million in, and the other 2/3 of the customers would have brought in 72 million. So the logic of the argument is that economically, a third of all these residual costs are being used to generate 4% of the revenue. And it's not a matter of necessarily you agreeing with my analysis or not, but it plainly shows the rationality of the Upper Tribunal's decision in finding that customer numbers do not necessarily reflect economic use and didn't in this instance. And I think, as my Lady Justice Whipple said yesterday, that the logic, in the sense of a customer number method, is that the economic use of the residual cost is the same for every customer. Whether he comes in to buy a single drink or a high-value gamer, and the tribunal is entitled to reject that. There is complaint that the Upper Tribunal was somehow finding that in all circumstances the standard method would apply. And respectfully, I don't think there's any real basis for that. They plainly accepted that it can be displaced, and they addressed in detail whether it was in this case. And then finally, and to some degree, these submissions are obviously in the alternative. HMRC don't accept that the standard method needs to be defended. But if it did need to be defended, well, it's easily defended in general and in the facts of this case. There is no good evidence that in any of the years in question, the economic use of the residual costs was significantly different to that being determined by the standard method. Now, in a sense, there's a certain circularity to that submission, because it goes back to the point of, well, you can't get to economic use without a method. And all the ones that have been advanced are wrong, for the reasons I've said. But nevertheless, on any view, that the point remains that one can't say, oh, well, it is obvious for X or Y reason that the rent of the building is not being used 12%, 13% for taxable reasons, and the rest for gaming, not least when gaming was the only thing that was bringing profit in. Second, the primary performance indicator considered by Hippodrome Casino Limited's board in the period was revenue. The witness statement of Mr. King, the managing director, very sufficient to go here. It's in the supplementary bundle at page 63. In paragraph 30, board review the performance of the profit centres, so the various aspects of the business we call profit centres, by reference to the revenue generated by each of them. Revenue is the key performance indicator used by HCL because driving revenue levels up has been a major focus of the business since opening. So another way of looking at it is the appellant is using residual costs to drive revenue of its various businesses. That being said, there's nothing prima facie unreasonable about apportioning those costs by reference to the revenue thereby generated. And the turnover method obviously also changes as the business changes. So take the theatre. There were years of trying to use it as a strategic gaming asset. Ultimately, it didn't seem to succeed. And in 2018, they decided to launch the Magic Mike show, and record-breaking box office pre-sale receipts came in. And in June 2018, which is just outside the periods under appeal in the SMO aspects of these appeals, in that period there was a 33% recovery rate. So, you know, you've changed your strategy, using that more directly to bring in money through Magic Mike, and lo and behold, you've got a higher recovery rate. So that is some indicator. And obviously, the standard method is rough and ready, and I'm not going to go behind it, but it's also not entirely arbitrary. And I think I've probably already adequately dealt with the related point about the proposed alternative method or effectively being suggested in respect of customer numbers. But just to get into the weeds of this a little bit, to make good the point that the evidence is obtained in light of the arguments understood to that point. I think we were in the supplementary bundle at page 64, the paragraph 32 of Mr. King's statement. Third line down. We are generally unable to accurately
sorry, I
measure.
haven't got there yet.
Oh, so
Page
sorry.
64.
Page 64 of the supplementary bundle.
Yeah.
Paragraph 32. Managing director saying we're generally unable to accurately measure the attendance of individual profit centres. Don't really know what people come in to see. At page 115, page 123 of the transcript.
So that was page.
Oh, so page 115.
Thank you.
I apologise. It's I think it must be tab 6. And it's page 123 of the transcript, and this is during cross-examination of the Chief Executive, Mr. Thomas. I'm picking it up at line 11. And he's saying the poll data is 6,300 people over nearly 2 months, spread over 2 months. We get 6,000 people on a Saturday. So if you were to do the poll just on a Saturday, you get a completely different result to that. I don't know what time the poll data was done, but doing it over an average of whatever, 100, 200 people a day, it's a very small sample. It depends on what time it's done. But certainly if you were to do Friday, Saturday evenings later on, you get a completely different balance. And then over the page at 126, and these questions at this point were on a sort of a secondary argument that HMRC were running in the tribunal, which was to say, the general space, there's a lot of general space in the floor method being apportioned by your use of the main method. So even on your case, 50-50 doesn't seem to be right about the use of the corridors and so on. And Mr. Thomas here says the general area is being split on a 50-50 basis. There's
Sorry, where are you?
Sorry, I'm at page 126, line 12, and then the response at 17.
I see, yes.
And the witness's response, visits do not equate to economic use. Now, if there was a footfall method being determined or anything else, then the shape of this examination would be different, and so on and so forth. And so HMRC does say that there would be evidential prejudice, or there is evidential prejudice, if HMRC were having to respond now to an alternative footfall-based method. And so, were you to be against me on all the other aspects, and you're thinking, well, what to do? Well, yes, it does follow that it would not only need remission, but need remission for repleading further evidence and the rehearing.
Apologies if I haven't quite got it. The point I think that Mr. Hitchmo made was that the Upper Tribunal's dismissal of this evidence, which was on the basis that the gambling customers spend more, that was sort of turnover method by the back door. So what they're really saying is that wasn't a properly reasoned conclusion. I don't think they're challenging that the Upper Tribunal could deal with this evidence as part of all of the evidence, but they say that the explanation for setting it to one side was not sufficient. Could you just help me with that?
So I think the answer to that is it goes to, if the point you're asking me is, well, the criticism in the sense is that this was an insufficiently reasoned aspect of the decision, what's the response? And that's the point at which the contextual nature of the application of the Flannery type principles applies. What is required of a judgment? Here, they're into an obiter section because paragraph 195 follows on the premise that they've rejected, which is that the standard method needs to be justified, or looking at the problems of the standard method. So, if they've taken it shortly,
they actually didn't need to say anything, did they?
Yeah, they didn't need to say anything.
They didn't need to say anything, but they didn't need to touch that evidence.
No, they didn't need to. And if they have, then they could have dealt with it at greater length. But it was a passing point. It's not the centre of the case. Unless I can assist further, that's round 3.
Round 4.
Round 4, and it's at this point you think, oh wow, coming to the end of the morning, and I'm going to be asking you to think about slightly brain-melting scenarios, and so please stick with me. On ground 3, before we get into it, I would just like to give a little, very brief background to the clarification on HMRC's position in respect to the EU law point. So, if you please could turn to the authorities bundle at tab 1 and page 10. You have, in somewhat small font, Article 176. And the first paragraph of 176 obviously has 2 sentences. The first is that the Council shall determine, acting on a proposal from the Commission, shall determine the expenditure in respect of VAT, in respect of which VAT shall not be deductible. And then the second, VAT shall in no circumstances be deductible in respect of expenditure which is not strictly business expenditure, such as that on luxuries, amusements or entertainment. And then obviously the second paragraph, pending the entry into force of the provisions referred to in the first paragraph, Member States may retain the exclusions provided under their national laws. And there have been no provisions, and this provision followed one of the 6th VAT directive in the same lines, which we've seen in Thorny and to which I'll return briefly, which is 17.6, if you recall. But the Council has never identified the expenditure in respect of which VAT should not be detectable.
So paragraph 1 has never been activated, is that the
exactly?
Except for the second sentence.
Well, and that's the ambiguity. Exactly, my lord. Because on the second sentence, there's an ambiguity of whether that already is a substantive law, or whether that is merely saying that as and when the Council enact those provisions, the Council is limited in their ability to do so because it can't, or in the sense it must not allow expenditure which is not strictly business expenditure to be deducted, including entertainment. So that's there's a certain ambiguity there.
What about whether it needs a Council measure to bring in the second sentence?
Exactly.
The second sentence is
Exactly.
part of the existing law.
Exactly.
Okay.
And then if you go to tab 5, which is Thorny MI, and you could go into page 196. And at the top of the page, you have the provisions of Article 17.6 under the predecessor directive, the 6th directive, in similar terms. And then at F, the paragraph at F, it's recording that the Council of Ministers has not yet adopted the proposal as envisaged. The exclusion of goods or services used to be used for the purpose of entertainment from credit for input tax, however, has had effect from the entry into force of the directive and is not conditional on the implementation of any future decision, seeing the Intiem case there. So, I think my learned friend Mr. McGee took you to Lord Justice Hobhouse's decision in similar terms, which you find at 198A, likewise saying under Intiem, that provision is effective. However, subsequent jurisprudence from the European Court has put that somewhat in doubt. And given that we're not proceeding with the argument, I hope it will suffice to take you to X holding, which is in the second authorities bundle at tab 12. These were joined cases concerning the right to deduct VAT for certain categories of expenses under Dutch and European law at paragraph 36 of the judgment of the court, which you find at page 354. And you see the referring court ask essentially whether Article 17.6 of the Sixth Directive authorised a member state to exclude from the right to deduct input VAT a certain number of goods and services listed in national legislation, having regard to the fact that the legislation was applicable when the Sixth Directive entered into force. And then at 39 over the page, and perhaps I can just invite you to read 39. So just note in particular the final sentence: European law therefore does not yet contain any provision listing the expenditure excluded from the right to deduct. And then also...
sorry, where was that?
Oh, I'm sorry, my lady.
So
we're paragraph 39, and then the final sentence of paragraph 39.
I think I'm in the wrong bit.
I'm so sorry.
AG.
Page 355.
Yeah, sorry, I was in the AG. Classic schoolgirl error. Yeah, sorry, thank you very much.
No, that's fine. So we had started at 354.
I've got it.
At 30, and then, so I'll just let you read 39.
Yep.
And so it's the final sentence. European law does not yet contain any provision listing the expenditure excluded from the right to deduct. And then over the page, at 54 and 55, just invite you to read those. And in particular, obviously, it's 55, which says, if the council does take legislative action, expenditure which is not strictly expenditure is under no circumstances to be deductible. So it's if. So it's not saying that that second sentence is already applicable. So it's making the point that if there are the provisions made, then they have to.
In the meantime, one is left with the national legislation.
Exactly. And so that's why, on reflection, HMRC aren't pursuing the EU law point. And I'm sorry to have taken the court's time up with it. For your background note, if one was interested in the history of the input tax order, there is in the case of PwC, PricewaterhouseCoopers, perhaps I should describe it as tab 15, just for your note, powers 5 to 16, basically a history of that order. The input tax block, in fact, predated the Sixth Directive. So the UK position has predated the Sixth Directive. And there have been some twists and turns in its history since then. In particular, an aspect of it was extended and then taken away again. but none of that we need to trouble ourselves with, but just were it to be of interest in due course. So, I have three submissions on why my learned friend's case on how the input tax order operates, why that's wrong.
And are we back to the legislation for this, really?
Yes, exactly. Thank you. The first is that the appellant's construction of how Section 25 VAT and 26 works produces absurd results. The second is that a workable construction of Section 25 is entirely possible. And the third is such an approach is in keeping with the general tenor of the Court of Appeal's approach in Thorne EMI. So, on the first point, produces absurd results. My learned friend's argument is that the entertainment block takes effect under 25(7) only once the input tax credit under Section 26 has already been worked out. So you do that first. There are then three possible scenarios on his case. First, there's the scenario where the business entertainment has only been used to further taxable supplies. On that scenario, his case is that there is then credit resulting from Section 26 upon which the input tax block operates. The second is that the business entertainment has been used to promote exempt supplies. In which case he says, well, nothing is coming in terms of the credit from Section 26 relating to that use. So there's nothing further.
He says it's already been taken.
Exactly.
It's already come out in the wash.
Exactly.
If you like.
So that's the second scenario. And then the third scenario, which I think happily we won't need to work through, is the mixed scenario where the business entertainment has been used for both. Now,
to which he says, I think, just to get it straight, you do another apportionment.
exactly, you've got to work out how much has been used for the taxable and then restrict in proportion to that taxable element. So, actually, I'm going to take them out of turn slightly, and I apologise for that. But can we take first the use only for exempt supplies scenario? So that's my second. And I'm going to use the example that I used before the Upper Tribunal, in which the Upper Tribunal puts in its decision, but with the modification in respect of the use of the business entertainment that I now need to make in response to how my learned friend has better articulated, or I better understood the articulation now. So the residual input tax, residual VAT input costs of £30,000. Those input costs are used for making, 1, business entertainment supplies worth £1,000, all to further exempt supplies. 2, taxable supplies worth £1,000. And 3, exempt supplies worth £1,000. So, standing back, the use of the residual cost has been a third directly for exempt, a third directly for taxable, and a third for business entertainment, albeit the onward use of my learned friends analysis has been for exempt.
I'm sorry, I'm just not sure I'm there.
No, that's right. So we have the residual input costs, which is the question we're trying to resolve. How should we apportion that cost of £30,000? And then you say, well, how has that been used? And let's assume a use, a third, for business entertainment, for taxable, and for exempt. And thus far, we have exactly how it's been put forward in the Upper Tribunal. But the next step is that insofar as it's used for business entertainment, it's being used to further exempt. So we're in the scenario 2 I've identified. This is a scenario where, on my learned friends analysis, there is no further thing to block once you're through the partial exemption. So that's the situation. Now, HMRC's analysis in that situation is, well, there's a restriction for a third of the use that is for business entertainment. So of the £30,000, only £20,000 has been used for taxable or exempt supplies. And then you say, so and what's the standard method apportionment? Well, it's 50-50 because the value of them are the same.
The remaining 20k.
Yeah, and so you get the result of £10,000. And £10,000 is a third of £30,000. So that answer accords to the fact that only a third of the cost was used for taxable supplies. Now we turn to what happens on HCL's analysis. Because they've got the same input tax of 30,000, but they say, so we go direct to the standard method first, and it's 50-50. So there's input tax credit of 15,000 from the operation of Section 26 and the VAT regs. And that's brought into Section 25. And then they say, well, there is nothing for the input tax order to bite on because all the business entertainment use was furthering exempt supplies. So the recovery is 15,000. And that's wrong. I mean, it's the wrong answer because only a third of the use of the residual cost has been for taxable supplies. And that, in effect, is the substantive position in this appeal too, of course, because the predominant use of the business entertainment has been for gaming. So the result of, and this is why we're arguing about it, the result of my learned friend's position is an over-recovery. Now, it's no answer to say that Associated Newspapers allows the deductibility of a cost of a voucher for promoting a downstream supply of newspapers, because there is no legislation precluding the deductibility of input tax on vouchers provided free. So while I follow my learned friend's principal point that in certain circumstances you can look through the immediate use of a cost to the, in a sense, downstream business use, it can't be operative in this scenario.
Well, because you say it's inconsistent with Article 5, because
Yeah.
Article 5 is clear as daylight.
Yeah. So that's the scenario in respect of.
So if you're completing that scenario,
I'm
moving
completing
on to another one.
exactly, and then we can take a breath if my lords would like one.
Yes.
But just to reassure the court, I am almost there.
Yes.
So
So we'll start again at 2 o'clock.